Hello, this is Attorney Sherrod, Innovative Immigration Law, shared sports visas. Today, talking about some of the not fun parts of immigration law. Sometimes the results you want do not happen, and it's shocking. There's one thing that comes with the just disappointment for everybody when a visa is unfortunately denied. But there's also a certain amount of just real life factors to be considered when there is a visa that wasn't expected to have any issues, have some issues. The inquiry I'm discussing now is a situation where there was a O-1 filed for a former world championship boxer that wasn't active. And maybe it might be the case, we didn't know at the time, may never be active again. And there was an O-2 essential support staff visa attached to that O-1. And it was the case that the O-2 visa holder was actually very, very important, maybe even more important to the employer than the O-1 principal visa holder themselves. So the thing that happens when a O-1 or a P-1 gets denied and there are essential support staff tied to it is going to be pretty quick that the USCIS is going to deny those other visas. Sometimes they do it so quick they don't even know what they're doing. I had one case where we had two petitions filed for the same P1. One was of a shorter value as far as timeline, and then we had another one that was for 3 years. So when the one that was shorter got denied, USCIS denied the essential support staff visas that came with it, even though there was one clearly pending that was longer. So we had to email them to show them how stupid they are. You know, it is what it is. And they just went and reopened the case without us having to file any type of appeal or anything because they completely made a mistake. In this circumstance, the denial was very, very unexpected. And so when the denial came for the essential support staff, there was a pause, too long of a pause to determine from the employer side what's going to be next. Because when there's a denial, you get about 33 days to file an appeal and kind of keep the status going. Because when you are denied a visa and you don't have anything else there, you really have 30 days to figure something else out or leave the country. But there's sometimes, unfortunately, where that doesn't happen and the person stays in the country longer than what that grace period was. So what do? If you do not want to leave the country, which, you know, maybe you should, but you do want to stay, you never want to stay longer than 180 days because that's when you start triggering automatic bans if you get deported or if you try to consular process it by going out of the country, coming back in. So the best thing to do is file another visa application immediately and then provide an explanation, which is called Nunc pro Tunc, where you basically show USCIS what was the reason for the delay in addressing the out of status time. And you make it a good argument and you be nice about it because at the end of the day, it's at their discretion. They do not have to do it. So in this case, honey goes a lot more than hot sauce. So when you do your non-pro-tunc arguments, you're going to want to be transparent. You're going to want to show receipts, conversations. You're going to want to show whatever documents and timeline you can show to support what you're asserting of why the explanation is that you did not file a visa in time for you not to incur unlawful presence. In this case, there is a good argument and there's communications there to show there was confusion on whether to file another O-1, O-2 combination for everybody, ready to use another athlete, or have the person file a direct O-1 visa for themselves. And we have the communications to show that that was going on. So what we'll do in this non-pro-tunc is submit those screenshots to USCIS, being careful, of course, not to reveal anything that we do not want to know. That's none of their business. But to let them know, like, hey, there was an effort to work with our counsel, work with just the powers that be in the world to figure out the best way forward. And it's just something that didn't get done in the time that we wanted, but it was addressed. The other thing you want to show is a history of the beneficiary that's in question coming and leaving the country within the rules. If they've done it before in the past, then it's likely that this was just a one-off and not an indictment on who they are as a non-immigrant visitor to the country. And that's what you can do. Show prior history of complying with the rules and explain very well with documented receipts of why the rules were not followed in this one-off particular extraordinary reason. So I hope that answered your question about what to do about unlawful presence. The answer is make it short and supply a nunc pro tunc argument with exhibits to prove what you're asserting. Thank you very much.